The development of the legislative powers of the administrative or executive authorities in the form of the delegated legislation occupies a very important place in the study of the administrative law. There is as such no power granted to the executives to make the laws. Such power is delegated by the legislatives to the executives or the administrative authorities. Hence, it is expected from the legislative authorities that they should supervise the executives or the administratives to whom the power is delegated by them. Hence, MP Jain also stated that in a parliamentary democracy, it is the function of the legislature to legislate. If it seeks to delegate its legislative power to the executive because of some reasons, it is not only the right of the legislature but also its obligation as principal to see how its agent, that is executive, carries out the agency entrusted to it. So legislative control, or we may say parliamentary control, is one of the way to fulfill this right or obligation. We may state the object behind the parliamentary or legislative control is to keep watch over the rule-making authority, which is nothing but executive or the administrative authority, and to provide an opportunity to criticize them if there is an abuse of power on their part. Now, let us discuss the modes of legislative or parliamentary control. Initially, the parliament or the legislative authority has to decide how much power is required to be delegated for the completion of their task. Then executives use this delegated power and make delegated legislation. Both these stages require control mechanism. There are two modes of control, first direct and second indirect. Let us first discuss direct control. Direct control can be further categorized into direct general and direct special, out of which direct general control can be exercised into three ways. First, through debate. Debate takes place on the act which contains delegation. Members discuss anything about the delegation, including necessity, extent, type of delegation, and the authority to whom the power is delegated. Second, through questions and notice of the discussion. Any member can ask questions on any of the aspect of the delegation, and if dissatisfied, he can give notice for the discussion under the Rule 59 of the Procedure and Conduct of the Business in Lok Sabha rules. Third one is through moving resolutions and notices in any house. Any member may move a resolution on motion if the matter is urgent and reply of the government is unsatisfactory. Second category of direct control is direct special control. This control mechanism is exercised through the technique of laying on the table, which means placing before the legislature, mainly Parliament. In England, this technique is very extensively used. Hence, in almost all the Commonwealth countries, this procedure of laying on the table has been adopted. Two main purposes behind the laying are to inform the legislature as to what has been done by the executives while exercising the delegated legislative power, and to provide the opportunity to question or challenge the delegated legislation which has already been made or proposed to be made. There are several types of laying. Let us see first, which is laying without further provision for control. Here the Parent Act merely provides that the rules shall be laid before the Parliament. They become operative from the date when they are laid before the Houses. In exceptional cases, even before they are so laid, this procedure is to inform the Parliament as to what rules were made by the executive authorities. Here, please note that we are considering Parliament as a legislative authority in our discussion for laying. Laying with deferred operation is linked with the postponement of the operation of the delegated legislation. The most common form of the parliamentary control is the laying with immediate effect but subject to annulment. Here the rules come into force when laid before the Parliament but cease to be in operation if disapproved by it. In the fourth type, that is laying in draft but subject to the resolution that no further proceedings be taken, there is the draft of the statutory rules which is required to be laid before the Parliament, but the Parent Act provides that the rules should not be made effective until the particular period has been expired. In the fifth type, the draft rules do not become effective until the affirmative resolution approving these rules has been passed by the Parliament. Sixth type is laying with operation deferred until an approval given by an affirmative resolution. The difference between fifth and sixth type is that in fifth type the rules were in draft, while in sixth one the rules were already made but they can come into operation when approved by the Parliament. The seventh type, that is laying with immediate effect but requiring affirmative resolution as a condition for continuance, is such a form of laying when the prompt operation of delegated legislation is essential but strict parliamentary supervision is also necessity. The confirmatory resolution keeps the delegated legislation alive which would otherwise die. Thus, type of laying depends on the provision of laying observed in the Parent Act. Now let us move to the legal consequences of non-compliance or failure with the laying provision. Just for comparison, we will see the situation in England. In England, the provisions of Section 4 subsection 2 of the Statutory Instrument Act 1946 makes the laying provision mandatory for the validation of statutory instruments. It is to be noted that in India, the laying of the rules or regulations framed under a particular statute for a specific period which that particular statute may warrant is governed by the rules of the procedure and conduct of business in Lok Sabha given in second volume of Parliamentary Procedure. As far as the consequence of non-compliance with the laying provisions is concerned, it depends on whether the provisions in the Enabling Parent Act are mandatory or directory. In one case, Narendra Kumar versus Union of India, Honorable Supreme Court held that the provisions of Section 3, subsection 5 of the Essential Commodities Act 1955, which provided that the rules framed under the Act must be laid down before both the House of the Parliament, are mandatory, and hence Clause 4 of Non-Ferrous Control Order 1958 has no effect unless laid before the Parliament. We may observe different view in the case of Jan Mohammad Nur Muhammad Begban versus State of Gujarat. Section 26 subsection 5 of the Bombay Agricultural Produce Market Act 1939 contained a laying provision. The framed rules could not be laid during its first session due to non-functioning of the Parliament due to Second World War. Here it was held that the rules remained valid because the legislature did not provide that the non-laying at its first session would make the rules invalid. We may observe the guiding principle in the case at Last Cycle Industries Limited versus State of Haryana. In this case, Honorable Supreme Court commented that whether the provision in the statute that laying of the rules made by the delegated legislation before the House is mandatory or merely directory, the use of the word shall is not conclusive. The intention of the legislature is more important in such cases. Second mode of legislative or parliamentary control is indirect control. Indirect control is exercised by the Parliament through its committees. With the view to strengthen parliamentary control over delegated legislation, scrutiny committees were established. In England and in India, there are standing committees of Parliament to scrutinize the delegated legislation. Such a committee is known as Committee on Subordinate Legislation. In India, it is present in both the houses of the Parliament. Both these committees discharge similar functions such as to ensure whether the rules are in accordance with the general object of the Act, whether the rules contain any matter which could more properly be dealt with in the Act, whether it is retrospective, whether it is directly or indirectly bars the jurisdiction of the court, and similar questions. Now let us see the effectiveness of the legislative control. It is often criticized that legislative control in India is more theoretical than practical. The ineffectiveness of the legislative control is mainly related to the growth of delegated legislation or the purpose behind the delegated legislation. We may summarize other reasons as executive's leadership, lack of strong opposition, absence of effective scrutiny on behalf of the whole Parliament, large size of the Parliament, etc. Since it is the legislature which grants legislative power to the administration or executive authorities, it is the primary responsibility of the legislature to ensure the proper exercise of the delegated legislative power and also to supervise and control the actual exercise of this power and ensure the dangers of the objectionable, abusive and unwarranted use by the administration or executive authorities. While concluding our discussion, let us have a look on the statement made by Honorable Justice Krishna Iyer, that is, the parliamentary control over the delegated legislation should be a living continuity as a constitutional necessity. Thus, parliamentary or legislative control is their right and duty as well as constitutional necessity, though it is criticized, its importance in maintenance of the good governance cannot be neglected.